Hello, welcome to Financial Insider Weekly. I am your host, Michael Gray, CPA. My guest today is Michael Demaray. Michael Demaray is a California attorney who principally works on lawsuits involving estates and trusts. And so I like to say about Michael, he's the first one they look for and the last one they want to see. So anyway, he's very well known in our community. He speaks for our estate planning councils and our bar association. We have a big annual powwow where we talk about the annual developments, and so Michael is one of the principal speakers related to that. Anyway, so today, Mike and I are going to be talking about your rights as a beneficiary. This is something that he's very intimately involved with. You know, talk about it in his sleep. So anyway, I'm just looking forward to a stimulating conversation with him about this. But some of you may be watching this from other states, maybe even other countries, who knows. So I just have to let you know that the laws can vary from state to state. So this is an introduction to this area, and it's intended to stimulate a conversation with your own attorney. Mike, welcome.
Thank you, Mike.
Okay. Mike, let's say a close relative died. How can I find out if I have an inheritance?
Well, there's always the old Michael Gray technique where you go to the funeral and you go around asking everyone, how much did I get? But in the absence of that, there's no governmental law or there's no governmental body that's supposed to tell you whether you inherited anything. It has to do with basically certain civil laws that turn on whether or not the person who died what we call either testate or intestate. When you die testate, that means you had a will or a trust or some document that tells you who's supposed to get the property. Intestate means you died without a will and without a trust, and in that case, your property goes according to the laws of intestate succession of the state of California. Of course, you don't know whether the person died testate or intestate because you don't know even if you're going to be a beneficiary. But basically, no matter who you are, in order to transfer the title to the decedent's property from one person to another, the title to the real estate, title to the bank accounts, there has to be some type of a probate order or some type of a trustee who can convey that title. And the law says that in order to get a probate order, if you died, say for example, without a will, or with a will, I should say, or without a will, they're supposed to file the will, and then in order to start the probate, they have to send notice to the people who are supposed to be notified. Those people are either the beneficiaries of the will and or the people who would inherit the will who inherit the estate if there was no will.
I see.
And you would get a notice in the mail. If there was a trust, the trustee is supposed to send out a similar notification within about 30 to 60 days, I believe, after the trustor, the one who set it up, dies. And he too has to send it to the people who would be inheriting under the trust, or the people who would inherit if there was no trust. Now you might say, well, if I'm a beneficiary of a will or a beneficiary of the trust, why should the people who would inherit, or who would inherit only if there was no will or if there was no trust, get notice? The reason for that is in case somebody who would otherwise be able to get the property by intestate succession wants to contest the will or the trust. So that's why both what are called the heirs at law, the ones who succeed under the laws of the intestate succession of the state of California, as well as the people who are the named beneficiaries of the will or the trust, both get notice. And usually you'll get that within about 30 to 60 days, but sometimes it could be much longer.
Great, okay. And so what are these notices like?
Basically, it's a judicial counsel form in the case of a will or an intestate succession, or a printed form in the case of a trust. It's a case of a trust, it says notification by trustee, tells you who died, whether he had a trust or not, and if you want a copy of the trust, they'll send it to you. The notification of the probate is a judicial council form which says on a certain day, usually about 30 to 60 days later, so-and-so will go in and ask to be appointed as the administrator of this estate. And that notification will often include both a copy of the petition to admit the will to probate or the petition to appoint an administrator if there is no will. And those petitions, well, if it's a petition to admit a will to probate, you'll get a copy of the will. If it's a petition to probate the estate under the laws of intestate administration, it'll list the people that are going to be the heirs at law.
Okay. Let's say I had a single mother, okay, unmarried. Father had passed away some time ago. And so she died about a year ago. I believe my brother is her trustee. But I haven't heard anything from him. Nothing's happened. What can I do to get things moving? What if my mother remarried and my stepfather's the trustee? That's two loaded questions.
Correct. The bottom line is that some people might have everything in what's called joint tenancy. The real estate may be in joint tenancy, the bank accounts may be in joint tenancy, or if there are bank accounts, they may be pay on death. In which case, in order to take title, the second husband or the surviving joint tenant doesn't have to go through a probate, doesn't have to send out a notification. For the real estate, he records what's called an affidavit death of joint tenant, which puts the house in his name. As far as the bank accounts are concerned, he simply goes down to the bank. The bank accounts are in joint tenancy with him. Sometimes they'll give him a death certificate to pull the money out and put it into his own account. And the same thing with a brokerage firm. So in that case, you may not get any notice. If you wanted to know, normally you would write to the second husband or the husband or whoever survived and just say, by the way, is there a will or a trust? If they don't respond to you, the tried and true method to find out if you're a beneficiary is to start your own probate. You go to an attorney. Usually it's better to do it that way, but you can do it by yourself. You petition to appoint yourself as the administrator on the grounds that you're an heir at law, and you send notice to all the other heirs at law. I guarantee you, if there's a will or a trust out there, those people will respond to that because they don't want you being appointed administrator if they're supposed to get it or if they're the executor or the trustee.
Okay. Let's say I'm the beneficiary of a will or a trust with a no contest clause. Does that mean that I'm shut out or can't challenge a will or trust? And what should I do in that case?
No contest clauses have been recognized in California for a long time. They are not what are called disinheritance clauses. A disinheritance clause is a clause that usually you only use if, let us say, you got married after you had done your will, or you had a child after you'd done your will. In which case, in order to avoid there being any confusion about what that child or that wife or spouse gets, you have to disinherit them if you don't want them to get anything expressly in the instrument. But a no contest clause basically says if anyone tries to break this will, then they get $1. So for example, if there's a will and it left you nothing, but if the will didn't exist, you would get everything, you might want to file a contest of that. And even if it had a no contest clause in there, you really wouldn't be worried about that because you're not going to get anything anyway. But let us say there was a will or a trust that said, I leave you $100,000 and I leave your sister $9 million. You might think, gee, that's not fair. I should get half. And if you go back far enough in time, you may find a prior instrument that left it 50-50. And you could therefore challenge that last instrument to try to break it. But if you lost, you wouldn't get the $100,000. So the efficacy of a no contest clause has to do with whether or not you are actually given something, and it's supposed to discourage you from trying to get more by punishing you if you do contest. Of course, if you contest and you're successful, then you don't have to worry about the no contest clause because the instrument that is contained in it is broken and doesn't apply.
Okay. We could probably have a week seminar on the details behind what Mike just said. I mean, as far as how do you go about challenging it and so forth. But this just again is something that you may want to talk about with an attorney. That's what Mike's business is helping people with these types of problems.
Let me respond to that just briefly, Michael.
Yeah.
If you were a child, for example,
Yes.
and you were left nothing, you would probably want to talk to a lawyer, because that's not entirely unusual, but there may be grounds for contesting the instrument. You have a certain period of time within which to contest it, depending upon when you got the will or when the notification was sent to you. So there's a clock running on the time within which you contest it, and it's usually a pretty short period of time. It could be 120 days, it could be 60 days.
Mm-hmm.
So you do want to talk to a lawyer in that case. But again, Mike, breaking a will, as it's called, or breaking a trust, isn't that easy.
Mm-hmm.
And there are many grounds, but the two main grounds are: one, at the time it was signed, did the testator or settlor lack testamentary capacity?
Mm-hmm.
Or two, were they unduly influenced to sign it? There are other grounds like menace and duress, but lack of testamentary capacity and undue influence are the two most common grounds.
Okay, good. Thank you. As a surviving spouse or the child of a decedent, what rights do I have, irrespective of the terms of a decedent's will or trust?
That's an interesting question. You might think, how could anybody have a wife and child and leave them nothing? It happens. And the state of California, in its great wisdom, has decided that a wife or a minor child should get something, and it's called a family allowance,
Mm-hmm.
or a probate homestead. Now, this only applies to a spouse or a child who's a minor.
Okay.
And under the laws of family allowance, in effect, it's a form of post-death spousal support or post-death child support. And it's computed based upon how much income the child or the spouse has, how much income is generated by the estate, and it's only paid pretty much during the period that the will is being probated. Now, if there's a trust, you don't get you don't get a family allowance, and you don't get a probate homestead.
Mm-hmm.
So in those kinds of cases, you're kind of out of luck.
Oh dear.
But if there is no trust, you might be able to qualify for a family allowance or a probate homestead.
Okay. Let's say I do have a dispute with my family over a will or a trust, or whoever, that I happen to be beneficiary or whatever, try to have a claim. Can I recover my legal fees if I have to take the executor or the trustee to court?
Usually the answer is no. In America, we have what's called the American rule. And in America, if you win a case or lose a case, you still pay your own attorney's fees. Mm-hmm. There's something called court costs. Court costs are the cost, the $500 fee to file your complaint or to file your answer. You may be able to recover those. You usually can. But most of the time, you pay your own attorney's fees. There are some circumstances in which your attorney's fees can be paid out of the estate if you win. There are things called the common fund theory. For example, if the trustee or the personal representative does something wrong, and there are many beneficiaries, but you're the only one that sues them, mm-hmm. and you're successful, under the common fund theory, you can ask the court to reimburse you for your attorney's fees out of the trust on the grounds that you benefited everyone by your lawsuit, mm-hmm. and therefore everyone should share in the costs. But again, those are not that common, but they do happen.
Mm-hmm. Okay. How long does it take to administer a typical estate or a trust?
Keep in mind, the main purpose of administration is to take the title out of the dead person's name and to legally put the title into the new person's name. In connection with the trust, that can be done within 24 hours, but it isn't, mm-hmm. because all the trustee has to do is sign a deed transferring it from the trustee to the new owner, go down to the bank and empty the bank accounts. He has the power to do that. But usually what will happen is it will take anywhere from 6 months to a year, maybe a year and a half. Mm-hmm. And it also depends upon whether or not you have a big enough estate to require a federal estate tax return. Mm-hmm. Now, given what's happened with what's called the exemption amount, estates that are only more than $5,340,000 have to file federal estate tax returns. Most estates are worth considerably less than that. But often most estates will consist of some real estate.
Mm-hmm.
And the people who are getting the real estate are often there's more than one person.
Mm-hmm.
So they don't all want to share a house. So usually the administrator will try to sell the house before he distributes the cash. And that takes as long as it normally takes to sell a house. In a hot market, it may be a couple months.
Mm-hmm.
In a slow market, it may be 3 to 6 months. Depends upon how much is listed for and that kind of thing. There are also issues involving creditors. For example, in connection with probates, decedent's estate proceedings, these are testate wills or intestate. You have to hold the estate open for a minimum of, I believe, 4 months, so that creditors can come in and try to get paid. And the personal representative has a duty to notify the creditors that he knows about, saying that the decedent has died, and if you have a claim, you must file it within a certain period of time, and if you don't, then you're cut off.
Mm-hmm.
So probates will almost always take about 6 months, at least maybe a year and a half. Mm-hmm. Trusts can be quicker, but again, if you're selling real estate, usually going to be about 6 months. And if there's a federal estate tax return, the estate tax return isn't due until 9 months after the date of death. And you normally don't pay the estate tax early. In fact, I can't think of any time you would, because for that first 9 months, there's no interest on the due date of the tax that's due.
Right.
So why pay the tax early when you get to keep the interest for the first 9 months? So that's why trust estates and even probate estates that are larger than $5,340,000 will not close for at least 9 months. There are things called partial distributions from trusts
Mm-hmm.
and preliminary distributions from the estate,
Mm-hmm.
where sometimes the trustee or the personal representative will go ahead and distribute part of the money now.
Mm-hmm.
But usually that's left within the discretion of the trustee or the personal representative.
Yeah. And as we say all these things, I guess we're saying as long as nobody is disputing anything, because if you have an argument, then I guess you could say all bets are off as far as when these things might be
That's
done.
exactly correct. You'd be amazed at how long a probate can go on. For example, whether there's a decedent's estate or a trust, if somebody files a contest,
Mm-hmm.
well, that's like any other lawsuit. There's got to be a period before the trial during which the parties get to take depositions, conduct what's called discovery,
Mm-hmm.
file motions,
Mm-hmm.
and then there's a calendar. You have to wait your turn to get on the trial calendar, and then there's the trial. And then after the trial, which may not be for 6 to 9 months after the contest is filed, the loser can appeal.
Mm-hmm.
How long does the appeal take? In California, about 2 years. So something that might have taken 6 months to 9 months in the absence of a lawsuit may take 2 or 3 years if there is a lawsuit.
And then there may be another appeal.
Usually not. Usually
yeah.
after the first appeal is over, but it depends upon what the nature of the lawsuit is.
Yeah.
Not all lawsuits in probate, Mike, are contests.
Yeah.
Sometimes you're suing the trustee because he did something wrong,
Mm-hmm.
and that can still take 2 to 3 years to resolve.
Yeah. And sometimes you could even have litigation over tax issues. So-
Exactly. You may
so
have an
not-
audit with the Internal Revenue
Yeah.
Service. Those are obviously becoming less and less frequent because there are fewer and fewer estate tax returns.
Right. Now, you mentioned the estate tax return due date, which is 9 months after death. But we can have an extension of another 6 months for that. And then we also have income tax returns that have to be prepared for the trusts. So, and states as well. So anyway, so there's a lot of things that can be time consuming. In some cases, you can be fortunate and turn things over fairly quickly, but you need to be realistic on your expectations, I guess is what we're saying.
Yeah, I'm talking about if you go to a
Yeah.
lawyer that knows how to do these things, you're talking 6 to 9 months, sometimes a year and a half. It depends upon how much there is to sell. And usually the tax returns have to be done, and you've got to know how to do them. But they usually don't hold up things too much.
Okay. So are accountings required for estates and trusts? And when do you think it's appropriate to waive an accounting?
The answer is the trust, even if it says an accounting is not necessary, an accounting is necessary. The reason for that is that California has decided that if you don't require the trustee to do an accounting, you'll never know if he did the right thing or if he stole the money.
Mm-hmm.
So yes, in both a decedent estate proceeding and in a trust administration, accountings are required. Now, what does an accounting consist of? Well, basically it's what's called a cash basis accounting. At some time before the trustee or the personal representative has been discharged, he has to send an accounting to the beneficiaries saying, this is what was there at the beginning, this is what came in, this is what was paid out, these are the gains on sales or the losses on sales, and this is what's left. And these things have to balance. They're usually not that difficult to read, and if they do balance, then he can then get discharged from any further liability. Sometimes, many times as a matter of fact, the trustee's attorney or the personal representative's attorney will send a letter to the beneficiary saying, how would you like to waive an accounting because we might be able to get the administration over with a little bit quicker, and maybe even save a little money. Some of that's true, some of that's not true. And some people will go ahead and waive an accounting. For example, if there are only two beneficiaries and one is your brother and you trust him, why are you going to make him do an accounting? Or if it was a real simple estate, there was only a house, it was sold, what's the need for an accounting? But by and large, you shouldn't waive an accounting. It doesn't take that much time. It is not that difficult to do. And the only reason it would take more time and be more difficult is if the trustee or the personal representative can't make it balance, in which case you have a problem.
Okay. What suggestions do you have to keep peace in a family of a decedent who had children from multiple marriages or relationships? We're going to do a whole program on second marriages, but maybe you can just throw out a couple of highlights or thoughts related to this interview.
Well, you don't have to go very far than your newspaper and open it up to find out that some famous personage may have died and had children by either multiple marriages or multiple relationships. The laws of intestate succession, for example, say that if you have a wife and the children, the wife gets all the community property, and the wife and the children split up the separate property. If there's only children, then the children get it. And it doesn't matter if the children are born in wedlock or out of wedlock. They all share equally. Are there fights between the children? Sure there are. A lot of those fights have to do with basically whether or not one of the children was made the personal representative. The other children might be afraid that that particular child might try to take advantage of their position. For example, let's say there were 3 children and 3 pieces of real estate, and the child that's the executor or the personal representative or the trustee has decided to leave one property to one child, one property to another property to a third. So long as those properties are of equal value, that's usually okay, but usually they are not of equal value. So problems can come up in the area of worrying about whether or not your brother or your sister is going to administer the estate according to the law and according to the will. And if they don't, then there could be fights over that. The most common fights are not necessarily between children as they are between the second spouse and the children from the prior marriage. As you can probably know, in California, second marriages are very, very common. I think over half of marriages end in divorce. And that would take up a whole additional subject, Mike, to talk to you about how widowers, for example, tend to tell different things to their surviving spouse and their children by the prior marriage, and then they die, and the surviving spouse and the children by the prior marriage get into a different fight over who's supposed to inherit the money. Those are significantly more common.
Okay. Like I said, we're going to do a whole program on that, so I'm not going to dwell on it. And also, we're running out of time. Does a gift or an inheritance have to be reported on a beneficiary's income tax return?
Yes and no. The inheritance is not income, so it does not have to be reported on your income tax return. But during the period of probate or trust administration, while the money's in the bank, it's earning interest. And when the distribution occurs, not only does the property come out, the interest comes out. And that interest flows from the trust out to the beneficiary. So you will eventually have to report the interest income, dividend income, even rental income, on your income tax return that covers that particular year. So to that extent, yes, you will have to pay income tax, but it's usually only on the interest, the dividends, sometimes the capital gains, if there is any, and the rent from the estate.
Right. And another item is if the decedent basically had earned some income in some way, so that person would have had to report it as income if he or she received it. If when their beneficiaries receive it, they also have to report it as income.
There's something called income in respect of a decedent, and that's
Right.
why you often have an accountant do the income tax returns.
Right.
Most of the time, the attorney will do the estate tax return, the accountants will do the income tax returns.
Okay, and some accountants also do estate tax. It depends on the attorney and the accountant, but an awful lot of attorneys seem to prefer to do the estate tax return. Okay, actually we're sort of running out of time, so I think what I'd like to do is just throw it to you for a moment or two, Mike, and let you throw out some final thoughts for, if a person is a beneficiary and what they might do or think.
It's often very helpful if the trustee or the personal representative tells the beneficiaries what's going to happen. In the old days, we used to have the reading of the will.
Mm-hmm.
We don't have that anymore.
Mm-hmm.
But an attorney for the personal representative or the trustee will often meet with the beneficiaries,
Mm-hmm.
or even maybe send them a letter telling them this is the process, this is what's going to go on.
Mm-hmm.
Now, it's that attorney, if he's smart, will tell those beneficiaries, I'm not your lawyer,
Mm-hmm.
I'm the trustee's or the executor's lawyer, but I can tell you what the process is going to be. And if more lawyers for the personal representative and the trustee would do that, there would probably be a lot less suspicion and worrying on the part of the beneficiaries. Many beneficiaries these days are getting their own lawyer
Mm-hmm.
to find out because they don't know what their rights are, they don't know what they're supposed to get.
Right.
Theoretically, they're not supposed to have to. Theoretically, the trustee or the personal representative has a fiduciary duty to them, not to take advantage of them and to do things as expeditiously and as inexpensively as they can. But sometimes they don't. And so sometimes the beneficiary will hire his own lawyer just to monitor things.
Okay.
Of course, you do that, you got to pay him out of your own pocket.
Okay. Well, Mike, we're out of time. I want to thank you so much for joining me and sharing some of your wisdom and insights for people who are beneficiaries. Folks, like I said, this is just the beginning of a conversation. We sort of scratched the surface here, but I hope that we've tickled your interest, and so you will get additional advice. With that, we'll see you next time on Financial Insider Weekly.